So good afternoon, everyone. My name is Alicia Bergen, and I just want to really quickly introduce the Perkins Coie panel. The title of the panel is Perkins Coie LLP Presents Labor and Employment Law, the Management Defense Perspective. And we've got a number of great panelists here today to tell you about different areas of employment law. We all work on the defense side. I'm not an employment lawyer. They all work on the defense side. So they'll be sharing that perspective. And I just want to jump in because we've only got an hour and a lot to cover, and have you guys each do a quick introduction of yourselves. So let's start with, we'll go in alphabetical order. Katiana.
Good afternoon, everyone. Thanks again for joining us today. My name is Katiana Aurelian. I am a counsel in the Labor and Employment Group at Perkins Coie. I am based in the Los Angeles office and went to NYU School of Law, started my practice in New York, but have been in LA for the past 7 or so years. It doesn't seem that long, but it has been, I guess. Still a New Yorker at heart. And my practice is primarily advice and counsel work, and that includes deal work. And we'll talk a little bit about that later.
Okay, T, you're up next.
Alicia D'Ambreville, I go by T. I'm currently in-house. I've been there 4 years at Burlington Coat Factory. I'm a director, senior counsel of employment. I graduated from Penn State Law in 2013. We are, for any Penn Staters that are on. I chose L&E because I did a summer internship. I came into law school thinking I would do sports and entertainment law and fell into L&E after a stint with the law firm where I just enjoyed talking to people. And you'll hear probably a little bit later, I'm super into reality TV, and doing employment law is really, it's really like being in a reality TV show every day. So.
Nice. Andrea, you're up.
I have to echo what he said. It really is. I always say that, you know, we need a theme song. But my name's Andrea Douglas. I am in-house at Pharmavite, which is the manufacturer and distributor of nature-made vitamins, which most people have heard of. Most people have not heard of Pharmavite. I went to law school in New York. I went to Columbia. I moved out here immediately after graduating because I hate being cold. I practiced labor and employment law. I think I decided to practice L&E probably for similar reasons that I think that T said, and probably other people would say. I like talking to people. I find the drama really interesting, and am never fail to be amazed at the things that people will do at work and expect to maintain their jobs. I love talking to people, so I think that that's probably my favorite part of my practice. And I like being in-house, as I've said. I was in a law firms though for, I'm not going to say how many years because that would give away my age. So a long time.
Okay, Neil, you're up.
Good day, everyone. It's a pleasure to electronically meet you. My name is Neil Fisher. I'm an employment litigation partner at Perkins Coie. I'm primarily based in our Los Angeles office, but my practice takes me all over. My practice involves wage and hour class actions, PAGA representative actions, and I also handle a plethora of the single plaintiff actions. I'm a Georgetown Law graduate, as well as a Georgetown undergrad graduate. I fell into labor and employment during my summer associate years, actually. I found it more interesting than the M&A work I was doing because, like Andrea said, I learned about the salacious details of people's private lives, and during discovery, found out about the stuff they didn't want to be public. So it was interesting.
And last but not least, we've got Adrian, and please let me know if I'm butchering the pronunciation of your names, which is shameful since I know you all.
So we also do have Lindsay as well. She'll be last but not least.
Oh, sorry, Lindsay. My bad. Lindsay, you're next in alphabetical order than Adrian. Lindsay, yeah. I'm so sorry.
Go ahead, Lindsay.
I didn't do that on purpose, I swear.
Sorry, my audio cut out for a second.
Adrian, you're up.
You're going to be, okay. Hi, everybody. My name is Lindsay Holloman. I am a former Perkins Coie attorney. I just recently went in-house a few months ago to one of our clients, and that client is Radnet Management Inc. Radnet is the largest, let's see if I can say this right, the largest outpatient provider of medical diagnostic imaging, i.e. X-ray, MRI, mammogram, all that good stuff in the United States. So quite a change from where I was working before. I am also a labor and employment attorney, defense side only, and have practiced for about, hopefully I don't give away my age, but about 10 years in law firm life before I transitioned to in-house. And I will say this, for the few months that I've been here, you don't see quite as many of the salacious craziness that goes on in like, you know, in the client side until you're there and you get the calls every single day. I also am in complete and utter disbelief at the things that people will do at work. I just, every day, I think I've seen it all. And then I get another call and I just am floored and shocked. So anyways, that said, I also, like Neil, am a Hoya. I went to Georgetown University for undergrad, and then I actually went to USC Law School for law school, obviously. And I'm happy to join you guys today. Thanks for having me.
Hi, everyone. My name is Adrian Patterson. I'm a labor and employment associate in the Washington, D.C. office. My practice is focused mostly on traditional labor work. I also do some employment counseling, a little bit of litigation, as well as investigations. For my educational background, I also went to the University of Virginia. I got my BA in philosophy there. Then I got my law degree from Georgetown University Law Center. So you've got 3 Hoyas on the line with you. I started my career as like a general litigator, but pretty quickly ended up working with partners that almost exclusively did employment work. I kind of preferred the human aspect of labor and employment, as you've heard, over something like, you know, a contract dispute between 2 massive companies, or, you know, the kind of like paperwork heavy aspect of other practices like bankruptcy. So I stuck with employment. When I switched firms, I got pulled into a lot of traditional labor work and really enjoyed that work. And I've been focusing my practice on that ever since. So yeah, thank you. Excited to be speaking with you all today.
So I realized I didn't introduce myself besides saying I'm not a labor lawyer. My name is Alicia Bergen. I'm a partner at Perkins Coie in the Los Angeles office in the commercial litigation group. I am a generalist, so I do a little bit of everything litigation. I've touched a couple of employment matters, but I am not an expert like these great panelists that you have. I'm also a big NABALSA supporter. I've been to every convention since 2012, except for the one that I think was in like Minnesota or something, because my grandmother had passed and had a funeral. And I am on the National Alumni Advisory Committee as chair, and you know, just basically support NABALSA all the way through. So that's who I am. It doesn't really matter that much. I'm just here to moderate this conversation with these labor lawyers. So let's get to the question of what is labor and employment law. We know from the introductions, there's a bunch of different facets of this, and I want to have our experts tell us a little bit more about that. So let's start with litigation, and T, if you can take that.
Sure. So I guess part of why employment law is really interesting is because you kind of get a ton of different exposure in different areas of law, right? So there's M&A parts of it, there's litigation, client counseling. The litigation piece, it starts, there's demand letters, right? So you're responding to those. There's charges, those are filed at the administrative level, so like the EEOC. And the cool part about that is that I'm barred in Pennsylvania and New Jersey, but I have an administrative law practice across the country. So I don't have to be barred in a certain state to go practice in front of most of the EEOC. Some few cities have weird quirky things, but for the most part, you kind of can travel the country doing employment law. And then there's your traditional litigation when you're thinking like state or federal court, right? They're filing it under the alphabet soup of employment law, Title VII, ADA that protects disability, ADEA that's with age. And then what I also manage in-house is our arbitration program. So we will litigate, it's kind of just like litigation in state or federal court, but you're in front of an arbitrator rather than a judge. So it's like I just rattled off what 5 different ways you're litigating in employment law. So when we talk about the variety of it, that really is kind of the meat and potatoes of employment law, the litigation side anyway, which is only a small fraction of it, which is why I encourage everybody to become an employment lawyer. So I'll leave it there and turn it over to, I don't know anybody else who has any insight on like the litigation side of employment law on the panel.
Well, we can keep it moving then and talk about counseling and advice, and we'll circle back with students' questions about all of these different areas then. So that's
onto the advice and counseling side of things. So I mean, we touched on the litigation component, and when we say that, you know, there are different aspects, I don't think any one person just does that one thing. Even if you're litigating, usually you're advising on not having future litigation in that area, or things you can do differently, or how to mitigate the risk. And so there is advice and counseling happening there too. And while my practice focuses in on the advice and counseling non-litigation side of things, but it's malleable. There's some give and take there. And on the advice side, I find for the client base, it's gonna vary, but when you have startup companies or our emerging company, venture capital practice, ECVC, has a lot of new companies or smaller companies or growing companies, and they have a lot of questions about hiring people in different states. And which I'm based in California, and California is infamous for having lots of employee protections, and so they want to get it right. So a big part of my practice is making sure that our clients are doing the things that they want to do, but making sure that they're doing it correctly, because they want to treat their employees right, but it's really tricky sometimes if they just don't know the law. So it might be offer letters, it might be wanting to know whether in a particular state they can have non-competes. I do a lot of trainings for, you know, sexual harassment, or dealing with leave issues. I mean, we are still dealing with a pandemic, and employers have lots of questions about how to treat their employees, how to make sure that if you're working from home, what they need to give their employees, or how to deal with accommodation issues. So we see a lot of that day to day.
And moving into, does anybody else have anything to add on counseling and advice? Okay, well then moving on to investigations, and Andrea, you're up.
So I think that investigations, you know, just as a general matter, employers have an obligation to investigate claims of harassment, discrimination. Typically, I talk more about harassment investigations largely because they're, you know, the most interesting and salacious. That's one of the great things about labor and employment law. You get to talk about sex and drugs at work. So I think that so in California also it becomes the adequacy of the initial investigation really becomes important in litigation, and whether the employer has conducted a fair and impartial investigation. So it typically is, at least at our company, it's usually tipped off by somebody making a complaint, maybe to the hotline, either an anonymous complaint, which can be annoying because it's hard to know, you know, hard to get more information from that person about what you're investigating. You know, maybe something as simple as my supervisor and my coworker are having an affair, and he's treating her better than he's treating anybody else, and as a result, I got this terrible evaluation. And, you know, not that I'm investigating that right now at all or anything, but and I want it to stop. And so you get to interview people, and really have to figure out to do that. You have to figure out how to ask questions, what questions to ask, what documents to start with. And it really is kind of like, you know, being a participant in your own reality show, which is something that I love and I'm a complete fan of. And typically, I don't know if other people find this, but it's like when you start one part of an investigation, I find that you know, you can have the sort of creep, like you find, oh, wait, oh, there's this other thing that I have to investigate too. Oh, okay. So it's not just harassment, then, you know, your boss also is, you know, made these comments to you based on your race. Oh, okay, well, let me do that too. So it sort of goes on and on and on. And then at the end, you put everything together, you get to, you know, evaluate people's credibility. And what I think it's a good thing to do, or it's fun to do for me, because people tend to like telling me secrets, and I just, you know, and I just sit there and nod and smile, and so you get all the information, and then you just put it all together and make recommendations. So I don't know if anybody has anything else to add. I think I was just sort of rambling, but.
What kind of secrets, without attributing the people? Like, are they like telling you stuff about their personal life? Like, this is juicy.
Yeah, you get to know, like in one that we were wrapping up last week, it was, well, you know, she has a drawer full of drugs, right? And then you go, no, I didn't know she had a drawer full of drugs. What kind of drugs? Well, she's got prescription drugs. She's got, you know, she also smokes marijuana at lunch, and that's probably why she fell asleep. And you're sitting there going, wow, no, I didn't know that. And that wasn't what we were really here to talk about, but thanks for that. So you find out about who's having affairs with whom. You find out about who actually does work, who doesn't do work, who goes to the strip club at lunchtime. It's fascinating stuff. Yeah.
Or when you get to read their text messages, once you get like a series of text messages back and forth, it is
so great.
It really gives Bravo. It is the best. Like, it is honestly the most interesting part of the job.
Yeah, investigations have a tendency to sort of definitely expand in scope sometimes. And sometimes, you know, you have a narrow scope that you want to keep it to, and maybe it doesn't expand, but a lot of the times you're learning additional things. I know I worked with Adrian, and I know we're doing different parts of employment law, but Adrian and I have worked on an investigation together, and it started with one person and then it kind of grew and grew. So investigations tend to do that.
You do.
Okay. Unfortunately, we're running a little bit low on time, so let's get to traditional labor. Adrian, we don't want to leave you in the lurch, and we want to impart some knowledge on folks.
Even more interesting, traditional labor. So labor law generally deals with unions, collective bargaining agreements, and other issues relating to organized labor. There's been a resurgence of union activity, and unions are becoming more visible in the media and popular culture. So it's a really interesting practice to be in right now. Just to kind of give you a little bit of background, the National Labor Relations Act is the law that pretty much governs all that traditional labor attorneys do. But you end up dealing with things like unauthorized labor practice charges, which are complaints typically filed against the employer saying that some sort of right was violated under that law. There's petitions by unions to represent employees. And when that happens, you end up having kind of like a full-blown, like almost like mini political campaign, and employees actually get a ballot to vote on. You also negotiate collective bargaining agreements, and that's that document that governs the relationship among the employer, the employees, and the union. And then also representing employers in disputes under those agreements, working with them on in arbitrations, which is typically how those disagreements end up being litigated. But yeah, it's I know we're running low on time on this section, but it's a really unique practice, really a lot of fun, and yeah.
So the baseball dispute that prevented like most of like the spring training season would fall into the category of traditional labor, for example, right?
Yep.
Okay. I'm learning here too. Okay, so we wanted to, in case you didn't notice, we've got a panelist of people that are at firms and people that are in-house, and we wanted to give our in-house folks a chance to talk about what it's like to be a management side lawyer, labor and employment lawyer, in a firm versus in-house, since they like have this perspective on that. So Andrea, if you could get us started talking about like your day-to-day life. We've kind of gotten a few glimpses into it, but you can go a little bit more into detail and give us the salaciousness if you want. And also like dealing with business divisions and all of that. And you can also draw on, of course, your law firm experience.
Sure. So when I went to And when I went in-house, what I thought that was going to be really great was that I was going to finally have just one client, and that I was going to, be working with this one client to, improve things and to, build better employment practices. But what you find when you get, at least what I found when I came in-house, was that yes, it's one client, but then there are all these different divisions, and those end up being, these individual divisions are all individual clients that you end up, working for. So I work very closely, because it's employment law, with HR, but you also have, when you're expanding, you may, or even better, like when you're working with putting out a product, marketing, and what really, and sales. Those were some of the really good investigations come from the sales professionals and stuff. And I use professionals loosely, and so you really are kind of, it's neat because you're working with, it is one client and it's one company, but every day is different depending on who you're working with. One of the things that I really love about being in-house is that I no longer have to bill hours. At the end of every month, having they say you're supposed to do it every day, enter and release your time every day. And every month I would sit there and, the last day go, okay, let's look at all of my pieces of paper and figure out what did I do this month? And that was stressful, but, you trade that kind of stress for, you really don't. I find that I don't get to plan my day, or I can plan what I'm going to do. And I can, wake up and have my to-do list, and then somebody calls, or, the other day when I was, going to do this prep for this panel, we had a workplace hostage situation. So, you just never really know. So I like it. I think that it's, day to day, what is it like? Ask me tomorrow or ask me the next Thursday. I just don't know. It's very different every day, but it's exciting.
I will ask you, and then I will continue to try to push plants on you.
I was looking at your plants in the background, and I was getting a little envious. So,
so Lindsay, you mentioned that you were the most recent transplant from a firm to in-house. Can you talk about the value of firm experience and making your transition?
Yeah, I've only been doing it for a few months now, but I can tell you it was great to come in-house after I had years of practice under my belt, right? And I really dabbled in a little bit of everything. I'm primarily a litigator, and I've always primarily been a litigator. So the idea actually going in-house wasn't something that I was really considering before. And then one of our prior partners who went in-house as the general counsel for RadNet is actually the one that approached me and asked me if I would be interested in coming in-house. And of course I told him no. I said, don't you want to be my client? He was already my boss's client at that time. So, and one of my good friend's clients. Anyways, but he did, he kept on making the package more attractive, and eventually it worked, right? So, but I will say, it helped when I sort of jumped in on day one to have experience, representing or doing union work, experience on the litigation side, because I was allowed to keep my litigation cases. It sounds like, Talicia, like you have that same experience, but that was a big sell for me. If I didn't have my own cases that I was going to be able to litigate, I wasn't interested in going. And so, I still get to keep my cases. The ones that I don't necessarily want, I can push out to Perkins Coie, but the other ones stay with me. So, but I will say this position is very different than the position that I was in as a counsel at Perkins Coie. I am now the deputy general counsel for RadNet. And so I don't only oversee employment cases, I oversee all litigation. My job is head of national litigation. I have a lot of cases that are outside of California, which I didn't before. We have arbitration outside of California. And even though I'm not barred, like Talicia was speaking about, outside of California, I can still handle those cases. And I'm overseeing outside counsel, which is good in some ways. And, frustrating others.
I think we lost you audio a little. Nope.
About now you can. Sorry.
These things happen.
Hear me?
Yes, but I'm going to use this moment to transition if that's okay, Lindsay. It seems like a
One more.
Okay.
I need one more sentence just really quickly. The other thing I would just say is the adjustment for me especially was knowing how to phrase things to your client. You have to know who you're speaking to and know who your audience is. Because if you say things the wrong way, these are your only two options and this is the option you should take, that doesn't always work, especially at the top. So you really, really have to think about who you're speaking to and make it the option of the client. Anyways, that's it.
Thanks, Lindsay.
Thank you.
And Talisha, if you could share a little bit on the value of diverse perspectives in labor and employment, and particularly on the defense side.
Yes, so I think that it's invaluable. So I will say that I'll preface it to say I'm in a decent sized legal department. So we have 75,000 employees across the company in 45 states and Puerto Rico, and we have about a 20-person legal team. Three of us are employment lawyers. I'm the only Black attorney in the legal department, and for a long time was the only attorney of color. So I think it's interesting in dealing with that because, in particular, my client base, most of our workforce is diverse, right? I'm in retail, so retail sales. Most of our sales folks, most of the people inside of our DCs are diverse. So having somebody that has a different perspective, has different lived experiences, is a real value for investigation. So what Andrea was talking about, people wanting to tell you their secrets. I don't know if it's being Black and female or what it is, or like if that is part of it, but people do open up. They will tell you secrets they wouldn't tell anybody else, right? Or if you're investigating race-based claims or gender-based claims, they're a little bit different when you're approaching it as compared to being a white male, right? So there's difference in those that diversity of thought and perspective and lived experience. And I think that's why you do see quite a few attorneys of color in employment law, because, and in litigation too. Those are two big areas where there's a high concentration of attorneys of color. I think largely because some of those inherent natural skills are really put on display, right? You can really pull from your wealth of lived experience in a way that's very different than your counterparts, right? That kind of helps you stand out. So I think it's invaluable, and more companies and law firms are focusing on it. So I do think it's a great time to be going into law generally as a person of color, but in employment law, there's just a bigger emphasis on inclusion and diversity efforts. And it's a great way to show value add, right? When you're bringing those lived experience and perspective into the workplace in your practice.
Thanks, T. I think that's a good natural transition to what the students are probably most interested in here is, what skills and preparation, education, what kind of courses do you think are necessary for this practice? And, as we said, there's many facets to a labor and employment practice, particularly in the management side. So we wanted to divide this up by, litigation, traditional labor, counseling, investigation again, and then, a little bit of if you're interested in going in-house perspective. So Neil, can you tell us, what types of skills, education, preparation you think are necessary to be a successful labor and employment litigator?
Sure.
And students have mentioned in here in their questions, like an interest in specific classes. So if you can expand on that would be great.
Sure. Well, first and foremost, I think having common sense helps a lot in the employment context, because some things you see stuff you wouldn't even do around your neighborhood, let alone in the workplace. So I would start there, having some decent common sense. Now, in terms of raw skill sets, one of the things that I see a lot that I really want this group to pay attention to as they develop in their careers is writing. And I'm not talking about knowing how to write a grammatically correct sentence. I won't disrespect your intelligence and assume you can't do that. You should be able to do that by now. But you have to understand the purpose of the writing in which you're engaged. You have to understand the difference between writing persuasively and writing to a client. Sometimes clients need you to write because they need to get approval for budget to resolve a case. The way you write that is going to be different than the way you write a persuasive breach for dispositive motion. Dispositive motion, I'm just talking about like a motion to dismiss, motion for summary judgment. So you have to pay attention to your audience when you're writing. It's really important. And towards that end, I don't know if law schools do a good enough job preparing students to actually practice law. One of the things I think you should pay attention to or really start to try to piece together on your own is seeing litigation, like a single lawsuit in its entirety. There are oftentimes when you start practicing, you receive assignments and projects, draft this, draft that. And for whatever reason, law firms in particular are horrible about helping people understand how one assignment connects to the next assignment and builds upon the next assignment. So for example, you all are familiar with a complaint, I assume. It initiates a lawsuit, and then you file an answer, or you file some sort of responsive pleading. Well, let's take an answer, for example. In an answer, you include affirmative defenses, right? And a lot of times you're going to see a bunch of BS in these affirmative defenses. They're not real affirmative defenses, but a lot of us like to put it in there because we're signaling to the court some of the arguments we're going to make. I won't go into all that now. But what I'm saying is, like, when you are drafting something like affirmative defenses, one of the first things I make people do who work on my cases is pull the jury book of instructions. Because if you're unable to resolve that dispute and it goes to trial, your affirmative defenses are going to help you win the trial. And you have to understand what you need to prove at trial. And if you understand what you need to prove at trial to the jury, then you understand how you do your answer, what sort of discovery you need to conduct, and how to position the questions when you do things like depositions. Not to mention how to argue a motion for summary judgment, and then how to prepare motions and eliminate and all that sort of stuff. So start to think about an entire lawsuit and not just projects as soon as you start working. In terms of like education, I will say that probably the most important course that I've ever taken and that I find most helpful in practicing law is probably philosophy. And I say that because philosophy helps you, it teaches you how to compose a sound argument, and then it teaches you how to deconstruct it, right? So you're gonna have the argument that you're making, but philosophy teaches you to pay attention to the premises that you set forth to build that argument and then reach your conclusion. When you're writing, you need to understand that you're proving an argument, and that argument needs to be supported by premises, which need to be supported by facts. So all of that plays a part. But I think, if you're in law school right now and you want to focus on some courses, take a general employment course. There are things that are probably never going to change, like the McDonnell-Douglas test, that you should be aware of. I would also pay attention to civil procedure. That's really important if you want to be a litigator, because I can't tell you how many cases I've won just because somebody didn't know what the hell they were doing. So pay attention to civil procedure. And then lastly, I would take a contracts course, because at a fundamental and foundational level, everything's going to be reduced to some sort of contract. And then evidence, pay attention to evidence. That I'm dealing with a case right now where the guy doesn't even realize that he messed up. So I think those are courses that are probably important for you.
And some of the others added other courses in the chat. I think we basically all kind of agree with you, Neil, on that. Thank you. How about for traditional labor, Adrian? What kind of skills, preparation, education, coursework in law school do you think would be necessary? And also just, soft skills and personality characteristics, if you will.
Yeah, for sure. So I think that this isn't just for traditional labor. I think it's for practicing at all. Is if your school offers like a clinic in the third year where you get like a third-year practice certificate, do one of those, especially one where you're able to maybe get in front of a judge. It helps. I was able to do that in my third year. It helps with your confidence, your oral advocacy. You have to write a motion. It helps you, practice those skills. And you're getting to practice, obviously with your professor. So you've got a lot of oversight and supervision. You can do it in a way that gets you really prepared for that first year of employment. The other thing, so for traditional labor specifically, since a good amount of the practice involves negotiating with an organization, namely a union, that the client's probably going to have a long-term relationship with, I suggest negotiation courses with an aim on like amicable resolutions. If you're going to have a relationship with a union for decades, you want that relationship to be overall positive. I would also say if your school offers it, a traditional labor class would be good, because there's a lot of nuances in the law and in the practice that are really counterintuitive. A lot of times when we're advising clients, like one of the first things we say is, a lot of times that employers make changes that they think are positive. Like you get a union petition, right? And you say, well, the employees are upset about pay. Let's just give them more money. And that sounds great, right? Like you're doing something nice, but that's illegal in the context of a union campaign, right? So these things that, you think you're doing the right thing, you think you're doing something good, when you're talking about traditional labor in that world, you got to be really cautious of those little oddities that it has. And the other thing is that if you're interested in practicing on the defense side, I would look at summer associate positions, research that firm to make sure that they have a robust labor practice and focus on getting experience that way. There's like a little bit of a tension, I think, between the defense side and the, in this area, just because there's a lot of, I just think, historically tension between unions and employers. So, having an internship at like the International Association of Machinists might not be the best, way to enter into, defense side of that. So I would say if you're interested in defense side, to look at working at a law firm in order to do that.
Okay, and Andrea and Katiana, can you weigh in on, the special skills and experience and education that would, support counseling and investigations work? And Andrea, if you can additionally weigh in on going in-house. T, I'm sorry, I took that from you. You can ad lib with it. I'm just trying to keep us on clock.
I would say that for investigations and counseling in particular, I think your soft skills are very important. Like how you talk to people, how you get people to open up, and for counseling, like, nobody wants to feel like they're being told by their lawyer that they're a moron, even if what you are thinking is, you are a moron. Why did you do that? You need to say it a little bit more diplomatically, that's an interesting choice, things like that. And so I think that clinics are really good for giving you the opportunity to actually work with clients. I did a clinic, I remember in my third year, that was not a labor and employment clinic, but it was prisoners and families. And so it was, pretty, working with people who had, real life stakes in play. I also think just for being in-house, one thing that Lindsay said, about like knowing how to talk to people and knowing, I think that one of the things that I figured out is like, if you don't know how to negotiate, because you were doing that not just at mediation, not just with, opposing counsel when you're litigating, but you're negotiating, with your clients also. And so I think like if you, a lawyer who doesn't know how to negotiate, the word for that is that person is toast. You need, so I would also recommend, some books. One that I found is, that was good is Crucial Conversations, also Getting to Yes. There's many more, but those are the ones that I think of off the top of my head. I don't know, Katiana, if you have something else that I can touch on.
I don't have any books off the top of my head, but negotiations is, I think, we've all touched on it. It's really important. A big part of counseling, I would echo a lot of what other folks have already covered in terms of coursework you can take and the kinds of classes or clinics, because counseling is essentially, you need to know what you're counseling about, right? So if it's to avoid litigation, you might want to know what's going on in terms of how the courts might, respond to a particular kind of litigation. And one of the, I think, interesting and exciting things about labor and employment is that it's ever changing. Like, there are some cases that aren't going to change, like Neil said, but there are always new laws. I'm barred in California and New York. There are always new laws. I mean, I know that I saw the announcement about the House passing the Crown Act with hair discrimination. California already has that. New York already has it. But these are the kinds of things you need to stay on top of. So it might just be reading, those alerts that come out. There are lots of them. When you start practicing, you get them for free at the firms. Staying kind of, you don't need to know every single detail because you're going to have to look it up anyway. But you kind of need to know where the issues are. And so if there are some key issues being litigated, you kind of, a lot of our clients have questions about non-competes. If it's in California, like, what are the exceptions? Things you need to stay on top of, just the legal landscape. But soft skills also very important. And when you're advising a client, I think Lindsay kind of said this, it's a business, and you want to, sometimes it's really helpful to understand the business so you can effectively advise them and give them options. But ultimately, a lot of this ends up being a business decision and a risk assessment and how much risk they're willing to take on. So you might think, hey, this is the safest bet, they should do this. And maybe that's not what they're going to do, because they might think that this risk is something they're willing to take. So you want to maybe phrase that as, hey, here are the options. This is the least risk, and this becomes riskier. And given your goal here as a business, I would recommend this, but ultimately it's your choice, right? So these are the kinds of things you want to think about when you're counseling, and those are the kinds of skills you might be able to develop more in a clinic. But yeah, those are my
Really
takes.
quick, Alicia, if I could add, I know we're short on time. I just want to make sure folks on the call, since it's the audience is law students, understand it. So for the folks that are in-house, all of us were at firms before, because you typically will not get an opportunity to go in-house right out of law school. So just want to flag that for people. So when we're talking about skills, I wouldn't identify a particular class for in-house, but specifically getting those skills at a law firm that will translate over. So we've talked about the things we do at firms around counseling, around risk assessment. If there's any class, maybe it's a business class, right? A class where you can learn how to read like ledgers, things that I didn't know how to do coming into my in-house role. But a lot of what I do is around budgets and helping other parts of the business that are non-legal. So some of those other skills or interests, I think, serve you really well in-house. But I just want to make sure people are aware that it's few and far between that folks hop right out of law school into in-house, but there are certainly in-house externship or internship programs. The Association of Corporate Counsel runs them. If anybody's in the greater Philadelphia area, I run that program for our chapter. Feel free to reach out. We're filled for this year. If you're a 1L or 2L, certainly we encourage you to apply next year.
And I wanted to just add one thing about negotiations, since we're all talking. You guys are all pretty far away from ever engaging in any sort of important negotiations, but negotiations, they're an art, and you're gonna have to learn how to find your voice and how you do best with connecting to folks and convincing them to take the direction you want them to go. So I would say try to get into clinics that allow you to like go to court, help out with like landlord tenant issues, anything that pits you against another person, where you have to learn how to negotiate at arm's length. That's going to stand you in good stead and make you feel much more comfortable and confident when you finally get to the part of your career where you're going to be trusted with negotiating on behalf of a company.
I agree. And if your school has a clinic, I did a clinic, it was really annoying, all the role playing, everything, and being videoed and stuff. But I did learn a great deal from that, including like the different types of negotiation styles and the ways that you can approach it, and like the role of gender and race in those negotiations and all of it. So if you have the opportunity, that is one skill that I 100% use. So thank you, everyone. We have, I believe this is supposed to end at 1:15 my time, so I think we have 13 minutes left. So I think we should turn to student questions. So the first question I have, and I think this was somewhat covered, but if we can like briefly circle back on it, which courts do you primarily practice in? Federal, state, or administrative? And do you need a specific bar admission to practice labor and employment law? And I feel like I can answer the second part of that. You just need to be admitted in the state where you're practicing if you're practicing in courts. I don't think there's a special admission. Maybe there's a certification you can get later. I'm not sure. You guys know this?
No, you just have to be admitted to the bar in the state where you practice. And then there are also, so like I'm barred in Virginia, so I can practice in Virginia courts. But if there's a case in a different state, as long as there's a local counsel, there's a process called Pro Hoc Vice where you can request the court and ask them to practice in front of them. So that's another way to do that.
And one thing I'll add, as defense side attorneys, manager side attorneys, we most often prefer to be in federal court. So you'll learn as you practice, there are differences in how state courts run compared to federal courts. Most of my practice has been in federal court until I went in-house, and everybody files in state court. All the plaintiffs' lawyers are in state court, especially in California. So you start learning those different ones. And then I think, as I mentioned earlier, on an administrative level, like the EEOC or their city or state counterparts, those are all over the place. You don't typically have to have any you just have to be a licensed, it's not doing have to be a lawyer, right? But you just have to be barred or licensed anywhere, and then you can go and represent your client in those different venues.
Great. Okay. This is another question that was raised. I'm going to skip. I think this is a good point to ask. Because of the human-centered personal nature of your work, how do you guys balance empathy versus doing your job and what's legal?
I like that question. I like that question. Can I take a stab at it? I'm not a very empathetic person, so I can't relate to that part of it. But what I will say is that being I don't know why you laugh. I will say that being a Black person, right? You're very sensitive to like race issues, right? And I know that one of the questions that I had for myself coming management, being on the management side, is how do you balance wanting to do the right thing by Black people when you have a complaint of discrimination, right? The way I reconcile it is that I see so many frivolous and BS claims that there needs to be a balance. That's why everybody's in criminal court, everybody's entitled to representation, right? There's so many just frivolous claims out there that you want to be on this side to identify when there are people who have legitimate gripes or who have really been discriminated or harassed and retaliated against, so you can act and compel the company to do the right thing by those people. A lot of times the companies aren't the one discriminating against people. These people are off making money, right? They've delegated a lot, and it's the people who are low wage people for the most part, or who are closer to the ground, who are engaged in this unlawful conduct. And those are the people, the bad actors that you want to help get out of the company. So that's how I reconcile my feelings of wanting to do right by my people, but at the same time dealing with these sort of cases.
And
I'll also
thank you.
say,
Okay, go on. I was just going to say, can we hear from somebody with some empathy? But thank you, Neil.
I think I've got some. I'll also say that I've been practicing about 7 years now. I have not come across a single client where they weren't trying to do the right thing. I haven't had a client where I've been like, oh man, like you guys are really awful. So I think I haven't had to have that type of balance, because most of the time the company is trying to do the right thing. If there has been a bad actor, they're interested in letting them go. Andrea was talking a lot about the internal investigations, right? The companies do those investigations because they're trying to get to the bottom of the issue. They're trying to find out who the bad actors are, and they're trying to resolve things. So I haven't had to do that balancing, because all the clients that I've ever worked for have been good people.
So I will say, I wish that was my case all the time, but what I will say is that, so sometimes you have to put it in perspective, right? So if my client has done something wrong, part of the advocacy piece is identifying that to your client to say, here's what it is. I realistically evaluate it. I'm not going to pay more money because it happens to be a Black woman who was wrong, right? Like my job is to protect my client, right? So I think you have to balance that. But some of it is also like having networks where you can talk about things like that. I'm part of the National Employment Law Council. Hope everybody here is. It doesn't manage side employment law. It is for attorneys of color who do manage side employment law, and it's a great outlet to kind of have benchmarking and perspectives and people that are experiencing kind of similar issues at work and things like that, right? So I think there's often ways to find outlets, but you do have to know that you are zealously defending what people often look at as like, the big bad company, right? Like the deep pockets. So there is sometimes that kind of tension between it, but you have to remember like your allegiance does lie with your client. And if that at some point becomes an issue for you, you may not be on the right side of the V. And we know people who flip, go to the other side and do plaintiff's work. It's quite lucrative. I wish I had the stomach to do it, but like it is what it is. You have to kind of know yourself and assess that as well.
Thanks.
Not really a fan of the plaintiff's lawyer, so I'm just not.
I know we defense side are like,
I wish I was, though, the way these settlements come down, especially.
Oh my gosh, they make so much money on such nonsense and frivolous crap.
That is not to say that we're gonna turn anyone away from, if you're really interested in plaintiff's work, there are people who need representation.
There are people that are actually victimized.
And if a claim were
Litigator, of course,
in front of one of our clients, I am sure we would, I started this in the beginning, letting you know that a lot of our clients, they want to do the right thing. Laws change, and like Neil touched on, they're not the ones making every decision. If somebody was terminated because, they were a woman, they were 40 or over, they were a Black person, I mean, these things happen. And if we did an investigation and Bob's supervisor was acting reckless, we're going to tell them, like, look, this person's a liability. If you want 5 more lawsuits, you can keep them on. Because again, it's a risk assessment. We're not going to tell them to fire them, but we might strongly suggest it unless you want 5 more lawsuits and lots of liability and exposure, right? So you tell them that, and they're going to probably fire the guy and settle this claim. So plaintiff lawyer who brought the case advocated for their client and got paid. So we're not,
I tell my clients to fire people. So
I tell my clients to fire people. I just say fire them.
yeah, I say fire them. I'm like,
I like to speak plainly.
As my client, to be fair.
And thank you for that perspective on empathy, y'all. Another question, and I think I could probably answer this one, even though I'm not the labor lawyer. Do you think it's feasible to switch tracks to labor and employment after initially practicing a different area of the law? I think the answer to that is yes, because you've heard that there's a number of different skill sets that come into that. I think it's easier litigation side because of the skill set, but Katiana may disagree. I think it also just depends on how far into your career you're trying to switch tracks, because you will have to.
I totally agree.
Yeah.
Yeah, I started off white collar criminal defense. I did entertainment litigation for a little bit, and then went into labor and employment. So,
and I think specifically, if you, oh, sorry, Neil.
No.
I was gonna say, if you're doing litigation, I mean, like we said, civil procedure, getting comfortable in front of a judge and crafting arguments and being persuasive, you're gonna switch the subject area, but you're still litigating. That skill is not going to go away just because now you're doing employment litigation as opposed to commercial litigation. It's different, but it's still litigation.
I agree with what everyone said. I would say though, it's not without a cost when you switch practice areas in the midst of your career, right? Because no one's going to pay for you to train. You do have to learn a new area of law. So I would say take the time to personally invest in yourself if you're going to switch over, so that you can start catching up to speed with your counterparts who are your sort of graduation year.
Okay, and one last question. I think we're getting close to time here. This was kind of related to empathy, but I think this is interesting. For folks that are in-house, I think this is, how do you balance like coworkers and relationships with coworkers, especially with internal investigations? Do you have to keep a distance like HR, or?
It can be messy.
Yeah. I'll say since I've now done a couple of investigations since I've gone in-house, but I will tell you, being that I'm still litigating, it's difficult because I have to pick and choose which ones I can investigate and which ones I do not want to investigate, because I don't want to end up in a position where I'm, breaching the attorney-client privilege for something that I later want to litigate on the outside or on the other side. So it's not an easy decision to make. I also say where they're really high profile, where it involves somebody really high up in the company, sometimes I just push that out anyways, because I don't want to touch it with a 10-foot pole, right? I don't want to get into those fights with the C-suite necessarily about, whether or not I'm making the right call. Again, I think it depends, but it's a very different position doing the investigations, I think, for me, at least in-house, than it was when I was doing them as an outside attorney.
So, and I will say, so I've been at the same company for the last 4 years. So I have relationships, like long-standing relationships with HR business partners, with other people in operations who are often the subject of complaints, right? So I handle the investigation, I may handle the demand, the charge, and I'm defending the company in the litigation, right? Just turning whatever different hat I'm wearing at the time. I think you have to be able to talk to people to be able to give them, we call it coaching in the moment at Burlington. You have to be able to coach them and say, you did some wild stuff here, right? This is how you should not be doing it going forward. Like there's that coaching pieces when you find it in investigations, and you have to have professional courage to be able to say that, right? Like if you're walking on eggshells with people when you're investigating, that's not the best place to come from, right? So you're balancing, like, I may not how do I put it? You want to be impartial in the sense of you don't want to let your prior relationships or dealings make you make a decision to say like, oh, this person certainly did it or certainly did not do it. You want to stay objective, but you also want to be able to utilize those relationships. Sometimes that's why we keep investigations in-house, because you're able to counsel and coach in the moment with your clients, your internal clients. So that way you have better outcomes in the future. So it's certainly a balancing act, and you're trying to figure out which hat you're wearing that day. But it's one of the benefits of being in-house, knowing your client a little bit better than sometimes outside counsel does.
Thanks, T. And I think we're almost at time here. So I just wanted to thank all of you for taking the time to prep and show up for this panel and share your practices and talk about Black lawyers on the defense side of things here. I believe you guys all have their information and like their bios and stuff in the HOVA app. So, you know, feel free to like Google folks, and I don't want to volunteer, feel free to Google folks and reach out, but you can reach out to me and I can answer some questions. And I'm going to volunteer the Perkins Coie attorneys. You can reach out to them for sure and answer questions. And I'll leave it to my clients and potential clients to let me know whether they want to be reached out to. But if for now, if everybody could just go on camera for me real quick, we like to capture pictures of these panels. And since we didn't see any of your faces for this past hour, we'd love to. No judgment. If you're like in a bonnet or anything like that, like that's life. Like, it's all good. But if we can get you, some of you folks on camera, I would super appreciate it.
Do you want to unpin people so that you can see them?
Oh, I'm looking at it on gallery view.
Oh, well,
I've already
I
changed
didn't know
my
that was an option. All right.
Yeah. So a few more seconds, so that otherwise it's going to be some pictures with some names in it. Okay. It's nice to see all these beautiful Black faces.
It's wonderful.
It really is.
Beautiful.
It really is. Okay, I'll do it. I'll take it at this. Everybody smile big. Give me a second, because you know a picture is a screenshot. So smile big and hold it for a little bit. That's one. There's two screens. Give me a second. By second, I mean, give me 5.
Jane has like a half smile going on.
Okay, and everybody smile big again for me, please. Okay, that's it. Thank you guys so much for being at this panel and for your insightful questions. I'm sorry we didn't get a chance to cover everyone's, but we are around if you have questions. Perkins Coie has always been a supporter of NBALSA. Well, for the last 10 to 12 years has been a strong supporter of NBALSA. And you know, we're also always here for all of you guys. So thank you so much for joining the Perkins Coie panel. And thank you so much to our panelists for their time, and to the NBALSA executive board team for organizing everything and, you know, making it go seamless. And everyone have a good day. Hopefully I'll see some of you guys at the happy hour later on.
Thanks, everyone.
Hi, everyone.
All right. Thank you, guys.
Bye.
Thank you.